I respectfully request that the staff provide a legal briefing on any potential impacts of this ruling or related appeals on public board managed lands and leases, and whether current acknowledgements practice have any legal or consequential implications regarding land certainty or Crown sovereignty.
So that is Vancouver Park Board Commissioner Angela Haer at a meeting earlier this week. Well, to talk about that point in more detail, we're joined by Aria Laskin. Aria is a partner at JFK Law in Vancouver, where she focuses on Aboriginal and constitutional law. Good morning to you.
Good morning. Thank you for having me.
Oh, thanks for taking the time with us. That was certainly an interesting beginning of a meeting. What are your thoughts after hearing what Commissioner Haer had to say?
My view is that, let's put it this way. I don't think that most people criticize land acknowledgements for fear that they do too much from a legal perspective. That's usually the criticism is the other way.
Right.
My view is I don't agree with her. I don't agree with her for lots of different reasons. However, so that's my first thought. My second thought is related to the broader fear and what I believe is misinformation circulating around the Cowichan decision. This is just one of the many kind of trickle effects of this upspring in panic that we're seeing.
Well, let's talk about that then. I mean, there is an impression out there that the Cowichan decision throws into question private property rights in British Columbia, especially where First Nations claim title to the land.
Yes, that's right. And although I will just note as well that I think what she was talking about was lands held by the municipality, which is actually a different thing, but that's
sure
neither here nor there. Just another reason why I sort of don't think that what she was, I think that she was coming from a place of fear rather than information, is my opinion, it's my impression.
Right.
In respect of the Cowichan decision, yeah, I mean, I will, a couple observations I have is that the massive media attention that I've observed came not as much after the decision, although it did come there, but much more after statements by public officials following the release of the decision. And that have created this insecurity and fear among people that there's somehow this massive sea change to private land. And I think we can see three different approaches. And actually, this goes back to what she's saying. The one approach is the kind of ostrich in the sand approach, head in the sand approach, which is what I think we see, saying, okay, we're not going to do land acknowledgements anymore, and that'll protect us, our private landowners, is artificial. I should say, I am sympathetic to and understand people's concerns. I think a lot of them come from the way the information's been portrayed in the media, but I'm not seeking to minimize those at all. However, there is a reality, which is that the reality of an illegal land grab that took place that is now being reckoned with. That's whether or not people are doing land acknowledgements. That's a reality, right. And ignoring it's not going to. This is a real problem. There's the other direction, which I think we've seen in some of the media that's come up, which is the total panic approach, like the sky is falling approach, saying, "Oh, that's it. They're coming for our houses," and I don't think that that's accurate either. What I do think is that if people are really concerned about this, what they should be doing is talking to their public officials and saying, look, go and figure this out. Go, in the case of Cowichan, go sit down with Cowichan and figure out what to do here. There are solutions.
Will it happen then on a case-by-case basis? I mean, when you have any First Nation land claim, it's in this province, it's supposed to be done through the BC Treaty Commission generally, which is, the province and the federal government and the First Nation itself. Mm-hmm. We've seen very little actually settled through the BC Treaty Commission, have we not?
Yeah, I was going to say the BC Treaty Commission, look, a lot of nations want to go that route, but it takes, we've been working at my office on some treaties that have taken, more than 20 years.
Yeah.
So, and lots of nations, there's also like a sort of ethical and moral and I would say jurisdictional view, which is that we don't need a treaty. These are our lands. Again, all of that said, and I will say that my firm JFK Law, we're putting up a blog post in a couple of days on this specific point because it's such an important point. The idea that there's underlying Aboriginal title to the land doesn't somehow automatically create this link that, oh, that's it, you know, you're off. What it does do is create a different, like I would say probably what happens is that the underlying crown title gets displaced by a different type of underlying Aboriginal title. But all land, fee simple land, like people, the idea that this sort of really changes the character of fee simple land, I actually don't think that's true. What I do think is that there needs to be some really serious negotiations now and discussions between I should say, First Nation and municipal and crown governments. And I think that if landowners are, you know, really want action, what they could do is go and say, hey, go talk and figure this out in a way that keeps us protected. That's a totally legitimate, you know, next step. And I'll just say there are examples of this, like the Haida have an agreement that literally recognizes their title and protects and recognizes the fee simple land nature of land ownership of private landowners in that area, so that we know this can work.
Well, right. And my recollection is that it was also a major issue during the Niska negotiations and the final signing of the Niska Treaty. In fact, I actually spoke with some fee simple landowners on Niska territory who told me the arrangement wasn't going to change.
So that's a great example. Like treaty is another area where this has been negotiated and navigated in different ways. It totally can be. I think again there is this. I think a lot of the fear comes from media misrepresentation, public official statements that have drummed up panic. The reality, and this goes back to the Park Board Commissioner's statement, we can't. The idea that the solution is to deny the reality is part of the reason that this issue remains such a sort of pertinent and live one so many years after all this happened. And I actually think it will be better for everyone. You know, this is a matter of moral, but also a matter of property security. If there is just a reckoning between the First Nation land, you know, title holders and the Crown government that says, what are we going to do about this problem in a way that protects everyone?
But will we not see a time where, you know, another court grants the right to traditional territory to a First Nation, and it happens to be land that is already occupied by settlers and has been bought and sold fee simple by the province under the colonial system?
I think we probably will. However, and this is another really important thing that, and again, I don't blame anyone for not thinking about this stuff. However, what is really important to recognize is that there's this issue of there's a factual issue around title, let's say, factual legal issue saying, okay, is there Aboriginal title? But there is always a next question, which is an equity issue, which is what do we do about it?
Right.
What's the right thing to do in this situation? And that doesn't like there is not an automatic through line that says there's title, so everyone there, you're kicked out, you're gone. And I have a really like the courts are so clear that they do not want to be the ones making those decisions.
Right.
What they want is they're happy to make declarations of law, and then the governments, you know, the First Nation and non-First Nation governments have to go figure out what happens. So it is hard for me to imagine a situation where a court's going to say, yep, okay, and as a result, all 5,000 people who live there, you're out. Like that's a really hard thing for me to imagine. You know, can I say with certainty, oh, no one's ever going to be, you know, have to move as a result of this? No, but the thing is, I guess, you know, I'm imagining, let's say I found out that my house was on like a really, really important sacred site.
Yeah.
Like maybe, you know what, in very rare cases, maybe that is the right thing. And honestly, the level of compensation would be extreme. Like no one is getting, let's put it this way, no private landowner is going to end up in a much worse situation than they are now. Like I just really don't think that's going to happen. And I wish that we were seeing some more calming statements from our public officials and media instead of panic-based ones, because I just think they're so off base.
And would a particular piece of land, though, being the subject of a claim, as we see in Richmond, does that affect, you know, the value of the land or the future of that person being able to sell the land?
I mean, we'll have to see. The value, I will absolutely not claim to be a real estate specialist, so that would be a lie if I told you I was. But you know, look, right now I'm sure it affects the value. But I think this is just so new. I do not think that down the road this is going to be. I think it is very likely that in 30 years, the sort of fear on this issue is not going to be there.
Right.
You know, the idea of the ability to sell. Here's the thing: as soon as in an ideal, going back to treaty, for example, this introduces this new when there's my view is that when there's an underlying Aboriginal title, the next question is, okay, so what are their laws around that land?
Right.
So in terms of the alienability of the property, like, could you sell this land? It's all going to depend on the rules and laws of the First Nation. But I just my suspicion, based on how analogous situations have played out, is that it won't be the kind of thing that is extremely disruptive for private landowners. And I also just cannot imagine a situation where those private landowners wouldn't also end up with some kind of top up from the Crown. I will also just note that in this case, because Cowichan wasn't seeking any remedies against the private landowners, the court said, no, they don't need formal notice. But the court in 2017 was very clear and said, if you want to tell people, Crown defendants, if you want to tell landowners, go tell them. Like, they were allowed to give informal notice.
Right.
And I will say I can understand why private landowners would have wanted to be there.
Yeah.
Like, I understand that. They weren't given that informal notice.
Aria, we're going to have to leave it there for time this morning. Really appreciate your time. Thank you so much.
Thank you for having me. It's a big issue.
It is. Thank you. And you take care. I'm sure we'll talk again.
Yeah.
Aria Laskin, partner at JFK Law in Vancouver, where she focuses on Aboriginal and constitutional law. We did request an interview, by the way, and a statement from Commissioner Angela Haer, but she did not get back to us by the deadline.